You are listening to the Aging Starts Now podcast, where it's all about responding with confidence to the legal, financial, and personal challenges created by a disability, unexpected illness, or aging in general. Join us weekly as elder law attorneys Barbara McGinnis and Chris Johnson, along with other members of the Johnson McGinnis Elder Care Law and Estate Planning team, talk about the tools, techniques, strategies, and services that will make the elder care journey easier for everyone involved. Get ready, because aging starts now.
Welcome to Aging Starts Now, the podcast from Johnson McGinnis Elder Care Law and Estate Planning, where we help individuals and families navigate the legal, financial, and personal challenges that come with aging. I'm today's host, Dana Hentschel, Outreach Coordinator at Johnson McGinnis Elder Care Law and Estate Planning. And today we're answering some of the most common and often confusing questions about probate. From paying bills after a loved one passes away to understanding creditor claims and what happens when there isn't enough money to fulfill every gift in a will. Probate can feel overwhelming, but helping us sort through it all is one of our attorneys, Mr. Ryan Hicks. Ryan, thank you so much for joining us today.
And thank you for having me, Dana.
Wonderful. So let's start with the most basic question, and that is kind of, what is probate?
Probate is the process where a court's going to validate the will of someone who has passed away. It allows for the debts of that person to be paid. And it's going to transfer ownership of property in accordance with the will, or if that person passed away without a will, it's going to transfer that property in accordance with state law.
Okay. So if someone has a will instead of a trust, then they are going to probate.
Correct.
Okay.
They would go to probate to the extent that they have a probatable assets. So sometimes people will pass away even though they have a will, but they won't have any probatable assets. So for example, if they own a house jointly with a spouse, that house is not going to be a probatable asset. Or any joint bank accounts, those are not going to be a probatable asset. Or a payable on death beneficiary accounts, those are not going to be a probatable asset. So even though they don't have a trust and they have a will, there may not be anything to ultimately probate.
Gotcha. So probatable things are things that aren't jointly owned or don't have beneficiary designations or payable upon death designations.
Yeah, it's property that does not have an owner associated with it after the deceased individual passes away.
Okay. Well, many people are often worried about paying bills after someone passes away, especially if your loved one didn't put beneficiary designations or didn't put payable on death on their items. How does someone pay the funeral expenses, mortgages, utilities, or other bills that they're getting?
For funeral expenses, sometimes individuals will have pre-purchased burial policy to cover the cost of the funeral. Otherwise, those expenses can be paid out of pocket by family members or other loved ones and receive reimbursement from the estate once the estate is officially opened.
Okay. So they can front the bill and get reimbursed, or they could just wait until the estate is opened and they have the means to pay through the estate.
Yeah, that's correct. So the estate can reimburse people who paid out of pocket for those expenses, or or you can wait until the estate is open, and then the estate would be responsible for paying those expenses.
Okay. So we also hear this question. If you're listed as a joint owner or beneficiary on a bank account, are you personally responsible for paying the deceased person's debts out of the money that you inherited?
No, you are not responsible for paying their debts. If you're a joint owner on an account, or you're a recipient of a payable on death account, ownership of those funds passes directly to you, and you are not going to be responsible for the debts of the individual who passed away.
Okay. And how long do creditors have to file the claims against an estate?
The lawyer answer to this one is it depends. If the creditor has actual knowledge of probate being opened, there's a 120-day creditor period for them to come forward and present their claims. If they don't have actual knowledge, they have up to a year to file their claims.
Okay. And what happens if someone comes forward after the deadline has passed?
After the year-long deadline is passed, they are barred from bringing that claim.
Okay. And what happens if a will leaves a specific dollar amount to several beneficiaries or charities, but there simply just isn't enough money in the estate to pay everyone in full? I mean, does everyone receive a percentage or gifts paid in a certain order? I think some people may think when they create the will that they're going to have this certain amount of money, and then, care cost and all these other unexpected expenses happen, and they end up not having that money.
Yeah, unless there's language in the will saying something different, if there's not enough money to cover those specific requests or the specific distributions, those amounts are going to be proportionally reduced. That's kind of why it's a better practice to leave a percentage of the estate rather than a specific amount.
Okay. And kind of along those same lines, what if someone is named as a remainder beneficiary? Is that kind of after all the debts, taxes, and specific gifts are paid?
Yeah, that's exactly correct. That refers to the residuary beneficiaries, and the residuary estate is anything that is left over after all the debts, taxes, fees, and specific distributions are paid. If there's nothing left in the residuary estate after that, the residuary beneficiaries do not inherit anything.
Okay, so they don't get anything. They don't even get like a little percentage because it wasn't written that way in the will.
Correct, because they're literally getting whatever is left over after everything specific has been given away.
Gotcha. So one concern that keeps people from opening probate, I think, is cost. So I know that probate can be different depending on the county that you're in, but who is responsible for paying those expenses before estate assets become available?
Attorneys' fees for probate in this area generally average between $6,000 and $8,000 to open up probate. And that's going to be for an uncontested probate. Sometimes it can be more, sometimes it can be less. In regards to who's responsible for paying them, typically that's going to be the personal representative. But in regards to being reimbursed for those expenses, administration expenses, attorney's fees, and anything associated with the cost of administering the estate, that's going to receive the highest priority of reimbursement on the back end once the estate is opened up. So while the personal representative may have to front those costs, they can be reimbursed from the estate once the estate is open.
Okay. So many people believe that putting assets into a revocable living trust completely shields them from creditors. So after the trust becomes irrevocable at death, are those assets still subject to creditor claims?
They're still subject to the creditor claims for the individual who passed away. So while the trust is irrevocable to the beneficiaries, it's still not going to be irrevocable for the initial grantor's or settlers of the trust. So the assets in that revocable trust do not shield those assets from creditors. Your trustee should notify all the known creditors and pay all the valid claims. So even though those assets will not pass through probate, creditors could still potentially pursue claims down the line.
Okay. So what are some of the biggest mistakes families make in the first few weeks after a loved one passes away that can complicate the probate process?
The first mistake that people most often make is the use of power of attorney documents. When someone passes away, a power of attorney document is no longer valid, so people still try to continue to use them after someone's passed away. The second mistake that people make is trying to access like financial accounts or credit cards of the deceased individual after they've passed away. The third mistake is that families don't think to secure the household. When someone passes away, sometimes you have family members or friends randomly showing up to the house and start clearing out the personal property of the house. Plus, you have people reading obituaries, see who's passed away, They may show up to think that the house is going to be unsecure and start looking for valuables that may be in the house. So make sure that house is secure. Hire a locksmith, install Ring cameras, or do anything that you think you might need to do in order to secure the home. And the fourth mistake that people make is simply they do nothing.
Well, yeah, when you've got to pay $8,000 to open probate, I can understand why they don't want to do anything. But if someone listening has just lost a loved one and isn't sure what to do next, what are the first 2 or 3 steps they should take before making any financial decisions?
First thing they need to do is to make the final arrangements and grieve. Spend time with your loved ones. So while making the legal arrangements are going to be important, those can wait a little bit. So make time. So make sure you spend the time to grieve and spend time with your loved ones. Then you need to locate the original copies of your legal documents. So find the original copies of a will, find the original copies of a trust, and to get an idea of what you're going to be looking at. The next step goes back to one of my previous answers, and that's to make sure the house and the valuables are secure. And finally, consult an attorney to help you through the process.
Well, wonderful. Well, thank you, Ryan, for helping us better understand the probate process and for answering so many questions that families often ask during this difficult time. If today's conversation has you thinking about how to make things easier on your family, or better yet, how to help them avoid probate altogether, we would love to help. The right estate plan can simplify the administration of your estate, protect your loved ones, and provide peace of mind for everyone involved. To learn more, visit us at www.tn-elderlaw.com or call 615-824-2571 to schedule a consultation with Johnson McGinnis Elder Care Law and Estate Planning. Thank you so much for listening to today's episode of Aging Starts Now. And if you found this episode helpful, be sure to subscribe, leave a review, and share it with someone who may benefit from the conversation. Until next time, remember, aging doesn't just happen one day. Aging starts now.
Thank you for listening to the Aging Starts Now podcast. For more information about today's show, visit tn-elderlaw.com, click on the Free Resources tab, and then click on Aging Starts Now. You'll find the show notes there. And while you're at it, why not check out all the free resources available at tn-elderlaw.com. Document downloads, the Johnson McGinnis blog, educational videos, informative articles, helpful links, a TV show, and more. It's all there, free for the taking. If you enjoy listening to the Aging Starts Now podcast, please subscribe, rate the show, or leave us a review. It's easy to do on whatever app you use to listen. We would love your feedback on the show. Aging Starts Now. We'll be back next week with more candid discussions about the challenges created by aging, disability, and unexpected illness.